students, I, Dr. Disha Siddiqui, welcome you all in Patent Law module. Patent law commonly belongs to the broad framework of intellectual property law. For instance, the mobile in your hand, the studio equipment where this current session on patent is recorded are all made from lots of research before innovation and undergone patent registration before introduction in the market. I would like to start my session with inspiring word of Thomas Alva Edison, who owns more than 1000 patents. He said that there are ways to do it, better find it. Now, let us discuss broad outline of today's session. First of all, we will be discussing the meaning of patent, the need of the patent, why we should opt for patent, what is the triple test before patent is registered. We will also see non-patentable innovation. We will see who can be the applicant for patent. We will see at length the patent registration process and its authorities. And the main thing is patent infringement and its remedies. Now, let us start with the first point of the discussion, the meaning and significance. If we talk about the history, the patent word arrived from Latin word petre, that means to lay open, which implied to make available for public inspection. If we talk about Indian Patent Act 1970, which we have to follow in the land of India, the section 2 subsection 1m of Indian Patent Act 1970 defines patent as a patent for any invention granted under this act. Now, the key word in this definition is invention. If it is not invention, it cannot be patented, and for invention there is a triple test given. First is novel. Novel means new. Firstly, the invention must be novel, meaning thereby that the invention must not be in existence in the market. For example, the mobile we have in our hand operates through operating system and its hardware design is protected through patent law, so that no other company can copy it. All new version of operating system has to file fresh patent whenever it is launched in the market. I recommend you all to refer to the famous patent fight between Samsung and Apple Corporation to understand this fact with a greater depth. The second component of triple test is non-obvious. Non-obvious means what? It means the invention must not be non-obvious, means invention must be a significant improvement in the previous version. Mere change in the technology will not give right of the patent to the inventor. It must be a significant change. And the third component is it must have an industrial application. If it is not commercially viable, it might be refused to get patented. It must be capable of being applied in any industry, which means that it must have practical utility in respect of the patent. We have also seen that patent has a limited term of 20 years, which is counted from the date of filing to the patent application. There are certain categories of non-patentable innovation. Few inventions cannot be patented, which is mentioned in the form of exhaustive list under the section 3 and 4 of Patent Act 1970. For example, the subject matter which includes method of medical treatment or diagnosis which is not patentable so as to control the expensive treatment charges for the public welfare. Now, the question arises, why an inventor research organization should apply for patent? The reason is very simple. One who do lot of hard work has to prevent their leaking of the invention by unauthorized person. We have also to prevent exploitation of invention by the competitor. We have to encourage research and development. And the very obvious reason is we have to stimulate capital investment that affect overall economy of the country. We have to encourage establishment of new industries. For example, after allowing process based patent in India, it has resulted into investment in our pharmaceutical sector, and we saw lots of growth in export by selling low price generic drugs in India. And it has given huge profit to our country merely by changing a law that is allowing process based patent in the pharma sector. A practical question arises, is patent globally granted? The big answer is no. The patent is a territorial right. Thus, it cannot be applied in the country where it has been granted. To obtain patent protection in different countries, each country you must apply for patent in that particular country. There is a term called PCT, that means Patent Corporation Treaty. It provides a way to file an international patent application in which a patent can be filed through a single patent application in a large number of countries, which is very good for multinational corporations. Thus, if we draw a lot of conclusion from previous discussion, patent is like a grant from government in the form of a guarantee for generally 20 years. It is a privilege for making, selling and using the invention. The implication of patent is it is a monopoly right to a person who has invented a new and useful article or done major process improvements. The term of every patent, as I told before, is 20 years and maintained by paying the renewal fee at every succeeding year. Now, if you have invented anything which really passed triple test, you must know how we register the patent. And before that, we have to apply for the patent registration. Now, there are three categories of person who can apply for the registration. The first is the true and the first inventor. Second is the assignee on his or her behalf, and third and the last category is legal representative of any deceased person. Now, there are provisions for filing patent application electronically by online system, as it is visible through the Government of India website ipiindia.gov.in. One can register for online filing of patent in a very easy manner. The IPI India, you can see there is a very user friendly graphic user interface through which you can apply and see the various modalities. We have to register for filing a patent application. The user has to undergo so many processes. First of all, he has to obtain the class 2 or 3 digital signature certificate, and he has to also apply for the user can register on the website after obtaining the digital signature certificate through creating his user ID and password on the website. There are so many benefits of patent registration. Section 70 of Indian Patent Act grant the right to patent owner, who is also known as licensor, to issue the license and earn license fee against license user, which is known as licensee. So, it is a wonderful business model in patent industry. The answer to the question arises in mind, why we innovate? Because it gives the immense money to the innovator or the R&D company in the form of license fee. Now, there is a very interesting terminology, the patent database. For example, if I want to innovate something, I must know whether it is patentable or not. So, there is a facility called patent database. How can one find out whether an invention is already patented? The person concerned can perform a search free of cost on Indian patent database as visible on the screen. Published patent application and granted patents are visible there. This database is available on Patent Office website. INPAS is the name of the database, and it is the URL which is easily seen. It also contained innovative tools under dynamic utilities, which gives information about the patent application at various stages of processing. Now, question arises, what are the authorities? What are the authorities who controls this system? The thing after registration, after protection, when we go and launch in the product in the market, my students, we face a lot of problem of copying our product. Our hard work is being used by some other person by unauthorized way. So, there is a thing called patent infringement. Patent infringement is a violation which involves the unauthorized use, unauthorized production and sales of another's patent. The basic idea behind patent infringement is that unauthorized parties are not allowed to use patent without owner's permission. Government of India under Indian Patent Act has given remedies for patent infringement. The remedies include litigation, we have to file a suit in the law and you are given monetary relief as well as injunction stop the person further from allowing the product, copied product which is used in the market. Monetary relief gives you whatever unauthorized sales the other person has made from your patent, it is given to you in the form of money. Let us look at the various types of patent in the international market. The first patent in that category is utility patent. Utility patent are one of the 3 kinds of patent present in the USA, but not in India. A utility patent may be granted to anyone who invents or discover any new and useful process like machine, article of manufacture or composition of matter or any new or useful improvement. There are so many kinds of utility patent. The most common type of patent application received by the patent office across the world are for utility patents. Such patent covers various processes, machine, composition of matter and manufacturers which are novel and useful to humankind in general. There are various kinds of utility patent. The first category is processes. Processes are defined as any method or act of doing something, typically involving technical or industrial processes. The example is a software process improvement. As we see, a major added process of voice search in different languages in a search engine is an example of utility based patent in process of software. The second type is composition of a matter. A composition of matter utility patent type refers to the chemical composition including a mixture of ingredient and substance or a new chemical compound. For example, pharmaceutical sector and invention of or utility of new drug discovery falls under this category. Third includes article of manufacture, for example, developing a new high-tech candle holder or a simple household mopper. The fourth category under utility patent is machine. A machine utility patent includes anything that is primarily regarded as a machine, for instance, computers, refrigerator, air conditioners and so many like that. In other words, utility patent is an exclusively right granted for an invention which allows the patent holder to prevent other from commercially using the protected invention without his or her authorization for a limited period of time. These are also known as petty patent, innovation patent or a minor patent. According to USPTO, that means United States Patent and Trademark Office, more than 90% of all patent granted are utility patent in the world. While one can obtain a utility patent for a new invention, one may also file for this kind of patent if they are making new and useful improvement or enhancement to existing processes, machine, matter, composition or manufacture. For example, a laptop is essentially a mobile computer and is considered an improvement of an existing computer. India does not offer utility patent. Currently, because of this, Indian innovators looking for patent registration file the utility patent. Countries in Australia, UAE, China, Germany, France and several other countries in the European Union. Now, after utility patent, the second category is design patent. The design patent is another kind of patent one can obtain in USA and other countries, but not in India. With reference to patent, the design is the surface ornamentation of an object. The design patent should include details such as the shape, configuration of the object invented or enhanced. To be eligible to obtain a design patent protection, one must ensure that the product's design is inseparable from the object. And while the object and design should be in synchronization, the design patent is only granted for and thus only protect the appearance of the object. The very common example is Google. The Google has a search page which is unique with colorful fonts. Google has received design patent for its uniquely designed Google search page, and this design made Google distinct from other search engine. A third and special category is plant patent, which is very significant for life sciences people. The third special category of patent is first primary condition is that it should only be reproduced asexually. Asexual reproduction, the act in which the plant is reproduced through cutting, grafting as opposed to reproduction with the seed. Asexual reproduction is mandatory for the plant patents. The focus of plant patent is primarily on unconventional horticulture. Like utility patent, currently there is no provision for plant patent in India, and you can apply for the same in Australia, USA, several European countries. All these countries you should go for when you want to register plant patent. Now the question arises, when should an application for a patent be filed? The answer is simple. An application for a patent can be filed at an earliest possible date and should not be delayed. An application filed with provisional specification disclosing the essence of the nature of the invention, it helps the inventor to register the priority of the invention. Delay in filing an application may result into some risk, such as some other inventor might file a patent application of the same invention on which you are doing hard work since years. I would like to quote a classical example of our highly respected scientist Dr. J.C. Bose. What happened with him when he delayed the application? It is a very interesting story in the patent world. In 1895, in the presence of the Governor of Bengal, Professor Bose transmitted an ether wave through a solid wall. Professor Jagdish Chandra Bose invented wireless telegraphy and demonstrated radio wave transmission in the year 1895 itself, but he did not file patent for his work. However, it was Dr. Marconi who was finally granted the patent in 1909 as well as Nobel Prize in the physics for his work, and the title was same which J.C. Bose has invented, wireless telegraphy. Eventually, wireless telegraphy led to the radio, television, Wi-Fi and even cell phones. The credit of innovation worldwide is given to Marconi, who filed the patent before Professor Bose. This live example indicate the importance of timely filing the patent application in competitive world. Now, the next interesting part of discussion is what are the types of patent application. The first is provisional application. Indian patent law follows first to file system. Now, in this system, a provisional application is an application which can be filed if the invention is still under experimentation stage. Filing a provisional specification provides the advantage to the inventor since it helps in establishing a priority date of the invention. Further, the inventor gets 12 months time to fully develop the invention and ascertain its market potential and to file the complete specification. The second category of application is ordinary application. An application for patent filed in the patent office without claiming any priority, either without any reference to any other earlier application under process in the office. Such type of application is also known as ordinary application. The third category is convention application. Now, under this, an application for patent filed in the patent office claiming a priority date based on the same or substantially similar application filed in one or more of the convention countries is known as convention application. In order to get convention status, an applicant should file the application in the Indian Patent Office within 12 months from the date of first filing of the similar application in the convention country. Now, fourth is PCT international application. As I have mentioned earlier, application filed in India as receiving office, that is RO, under Patent Corporation Treaty known as PCO. An international application which can be filed in more than 150 countries by single application, that is a great facility if you want to operate on an international level like multinational corporations. Now, fifth is a subcategory of the same, that is PCT national phase application. When an international application is made according to PCT designating India, an applicant can file the national phase application in India within 31 months from the international filing date or the priority date, whichever is earlier in the two, on comparing the two dates. The sixth category is patent of addition. When an invention is a slight modification of the earlier invention for which he or she has already applied for or has obtained patent, the applicant can go for the patent of addition if the modification is in the inventor of the invention is new. One of the benefit of filing patent of addition is that there is no need to pay separate renewal fee for the patent of addition during the term of the main patent, and generally it is 20 years and it expires along with the main patent. The seventh and the last category is divisional application. Under this, when an application claim more than one invention, the applicant on his own or to meet the official objection on the ground of plurality or distinct invention may divide the application and file two or more applications as the case may be for each of the invention. This type of application divided out of the parent one is known as divisional application. Original application is divided into two applications. Now, the question arises, when is an application for patent is published? Now, there is a timeline, let us see the same, let us discuss the same. Every application for patent is published after expiry of 18 months from the date of its filing. Priority date, whichever is earlier. In this, two dates are compared and the earlier date is given to you for the registration. To conclude the topic, I would like to say, and the final word of this discussion is, before an inventor files their patent application, they should recognize the application and patent type. It is recommended that they hire patent professional to assist with the patent filing process, which can be quite challenging if you carry it on its own without any consultant. All patents are government under the Indian patent law, which grants exclusively monopoly right to the patent holder and make him or her a millionaire through result oriented business strategies. If he sells the patent for commercial purpose, the person gets huge money, because his efforts are rewarded in terms of monetary contribution by the person, commercial people who are using his patent in products or services. So, I already told you it is an excellent business model and motivate us why we should go for patent, R&D and allied things. Now, after discussing whole patent, the technicalities, there are so many issues. Human society, the conflict is the part of human society, so is with the patent. There are so many case disputes related to patent. Let us discuss few landmarking cases which give you real feel of the subject and give you more realistic approach towards understanding the patent law. In this, the first case is referring to non-patentable innovation. This case is between Novartis pharmaceutical company and Union of India. The case was first filed in the year 1998. In this case, Novartis filed the application of patent for a cancer drug. Under this case, court prevented the company from evergreening their existing patent. The court rejected company's patent on the ground of newly inserted section 3D of Indian Patent Amendment Act, which provides that a known substance can only be patented if its new form indicate enhanced efficiency. The important element, obviousness and inventive steps, as explained in the definition of patent, was interpreted in this case by Supreme Court of India. In this case, it was observed that innovators who basically intends to continue their economic benefit by single innovation even after 20 years lapse of time, file the patent when it is 19 years, at the end of the life of the patent, file the patent with minor variant of the parent compound, the original patent, and they call them as second patent. Now, this practice is a bad practice. This practice is known as evergreening, which allows a prolonged monopoly that unfairly denies the common public to access essential medicine at a reasonable and affordable price. And we know pharmaceutical drugs are very expensive, and court has rejected the patent, and this decision of Supreme Court was welcomed by millions. It has really benefited the common people of India. And cancer treatment is very expensive. If it has got patented, the treatment could have been more expensive for the common man. This case is often quoted in the patent fight in the court. And second very famous case is between Vishwanath Prasad Radheshyam versus Hindustan Metal Industries. This is very interesting case. The plaintiff means you filed the complaint, was Hindustan Metal Industries, a registered partnership firm carrying on the business of manufacturing brass and German silver utensils at Mirzapur. In this case, plaintiff claimed to have invented a device and a method for manufacturing utensils, introducing improvement, convenience, speed, safety and better finish in the old prevalent method, which was risky to the worker, inasmuch as utensils used to fly off from the headstock during the manufacturing process. The plaintiff got the invention patented, and plaintiff learned that the defendant against whom the case was filed by the plaintiff, and the name of the defendant was Vishwanath Prasad Radheshyam, a concern carrying on the business of manufacturing the same item, that are dishes and utensils in Mirzapur, was using and employing the method which was already patented by plaintiff. The plaintiff served a notice upon the defendant asking him to desist from infringing the plaintiff's patent and further claimed monetary damages. The validity of the patent was challenged by defendant on the ground of lack of novelty and inventive steps, and also filed a counter claim praying that for the revocation of the plaintiff's patent on the same ground. The court as a result had issued the petition for revocation of the patent. The plaintiff made appeal to the divisional bench of High Court, where appellate bench concluded that the method of manufacturing did not involve any inventive steps or novelty. Furthermore, as the invention was publicly used by the patent holder before the date of filing of the patent application, the court observed that the novelty of the invention was negated. Finally, the plaintiff lost the case and his earlier granted patent was also rejected. In this case, the Supreme Court established so many principles. The Supreme Court explained and interpreted the object of patent law. It was held that the main object of patent law is to encourage research, development and innovation. This case is related to interpretation of inventive steps and non-obviousness in the innovation, which I have discussed in the definition part, and same principles was discussed at length by the court in this case law, which is often referred in all kinds of patent fight in the court. Now, third case is between Hoffman versus Cipla. Case filed by Hoffman against Cipla Limited, and an enhanced version was produced by Cipla Limited. It is a product versus substance dichotomy case. It is a technical term. The court has interpreted that the case is about when a substance becomes a product and how it becomes patentable. The court indicated that substance and enhanced efficacy led to a new product and novelty came up. Substance per se is not patentable, but a new product with enhanced efficacy is patentable. This case is also called Law Hoffman case. It is a very famous case in pharmaceutical industry. Now, the fourth case is Dhanpat Seth versus Union of India. In this case, Dhanpat produced Kilta. Kilta is a traditional agriculture instrument in the a kind of basket. So, Dhanpat produced Kilta, a like device using bamboo, which can be used for manual agriculture, and it was light in weight than traditional Kilta device. Dhanpat started to manufacture and sale of Kilta device, which Dhanpat has manufactured. Now, what happened? The Nilkamal Plastic Company also started manufacturing and selling the same device without paying the royalty to Dhanpat, and an objection was raised by Dhanpat. The Nilkamal Company replied that it forms the traditional knowledge. Dhanpat said that the original Kilta was painful in handling and heavy to use as well, and for this reason only they started using the device developed by him. Whether valid patent lies with Dhanpat in this case, Dhanpat Seth in this case was this was the question arise in front of the court. Now, second issue in this case was injunction, and the third was infringement, same was claimed. Court held that bamboo basket, commonly known as Kilta, does not complete the novelty step and the traditional knowledge clause as well. It was mere duplication of Kilta and the usefulness was not shown, and there is no inventive steps. The case was lost by Dhanpat and the Nilkamal Company won the case. Now, let us see to what extent can invention covering software be patented. This is a new category, and the module in which I am teaching you the patent law is cyber forensics and information security. There is always a question whether softwares are patentable or not. Now, there is a complicated theory given by the court. I am discussing the same. The patentability of software invention in India can be understood in the light of section 3K of the Patent Act 1970 and the guideline for examination of computer related invention known as CRIs. It is published by Government of the Controller General of Patent, Design and Trademark. Section 3K of the Act bars the patentability of computer program per se. However, recent patent grant to CRI by the Indian Patent Office indicate that software invention may be patentable if there are certain conditions, and these conditions are there is a technical advancement in the invention over existing one, and the second is invention provides a technical solution to the technical problem by providing a practical application or an improved technical effect of the underlying software. Further, the latest guidelines state that while examining a computer related invention, the patent examiner would focus on underlying substance of the invention and not the particular form in which it is claimed. To clear it further, for example, a mathematical or a business method or a computer program per se or algorithm are not patentable. As the wording clarifies in section 3K, the bar is on computer programs per se and not on invention containing computer programs or software. However, until the court decision in Indian Patent Office adopted a restrictive approach towards invention comprising computer software, as they are primarily granted registration under Copyright Act. This is the main reason.